An overview of business and human rights, I would say, syncs with the latest trends within the society, especially with reference of law. And therefore, we requested Shanti Samandha, K, an assistant professor, Law University, Tamil Nadu National Law University, Trichy, so that we can understand this particular aspect as to what is the interplay of business and human rights. She's a well-known resource person and she has acceded to our request. I'll ask ma'am to take over the session.
Thank you, sir. Thank you so much. Good evening, one and all present here. So I had a center called Center for Business and Human Rights at the Tamil Nadu National University. So that is how I inculcated my interest on business and human rights. With because I had interest on business and human rights, we got an fund from the Tamil Nadu government and we established the center. So thank you for this opportunity, sir. I hope I shed some light on this area of research as such. So first of all, the moment when we come up with this nexus of business and human rights, the first question comes to all of our mind is that what is the relation between business and human rights? Can business be connected with human rights? Because there is a strong paradigm shift between these two concepts as such. Initially, during the early days of 19th century or even before, the understanding of these two concepts of business and human rights was not there. So the conjunction that was used was business or human rights. One classy example is our famous economist Friedman, who clearly said that business is for maximizing wealth. Business is for making profit. Business is for taking care of its shareholders' rights, protecting the shareholders' rights, and nothing else. So the whole concept of business revolves around making profit and protecting its own shareholders and nothing else. So the propaganda or the agenda was that you should either concentrate on business or concentrate on human rights. So it should be business or human rights, and it cannot be anytime connected together. But slowly after that, there were a serious shift of thinking that business cannot get away from holding itself accountable for any kind of human rights violation. For the very basic reason, all of us are very much aware that these days the multinational corporations or the transnational corporations hold a higher influential position here. They influence states, they influence policy making, they influence lawmaking, they influence even the whole process of a state. They influence even democracy. All of us know how powerful they are. Sometimes we also understand that a company's annual turnover sometimes goes beyond a country's GDP. They make that kind of a profit. So when they are in that situation, now there are a wide understanding or acknowledgement that business and human rights have to go hand in hand. You make profits, yes, you make profits, but at the same time, it is your responsibility, it is your obligation to respect human rights. You cannot say that I have nothing to do with human rights because I am a corporation and I will just make money. That cannot be the case. So, from the aspect of business or human rights, now we have slowly shifted to the concept of business and human rights, where most of us agree that yes, corporations owe responsibility towards protecting human rights. Now, we are from business of human rights to business and human rights. Now we are slowly shifting ourselves to a next phase called as business of human rights. Now, what is this business of human rights? Is that we all know these days, especially with the concept of corporate social responsibility, and we all have this pride in ourselves that India is the first country which mandated CSR compliance, which is a legislative mandate, where the Companies Act 2013 mandates that every corporation has to have a CSR committee, and it has to look into it. It has to spend its profit on some kind of activity which fall under Schedule 7 or something related to that. So now this is slowly changing to business of human rights. Now everyone understand that human rights is very important, and only when I give some importance to human rights, I am going to survive the market. So this is the idea that has come to the corporation's mind. So now what they do is they come up with fancy ideas of human rights, propaganding themselves that they are very serious and they are very concerned about protecting and promoting human rights, but they exactly do the opposite. Say, for example, the washing ideas like the greenwashing, blue washing, the fem washing, rainbow washing. So, what is these washing are? These washings are something. Say, for example, let's take one example: greenwashing. So, what is this greenwashing? Greenwashing is something when a corporation claims to be environmentally sustainable. The whole business operations, whatever operations they do, that is up the value chain, down the supply chain, everywhere from taking their raw materials to when their product reach the market, the whole process they claim that it is sustainable, it is environmental friendly. We all know these days we are very particular, even when we get a dress, we see that whether it is a sustainable product, whether it is eco-friendly. This is something which is very commonly used these days. Eco-friendly products. So we are protecting environment, but at the same time, the same corporation does exactly the opposite. This is called greenwashing. So similarly with fem washing, which says that we protect women rights, we we are towards gender diversity. But when you just go and look into those corporates, gender diversified workplace, you don't see women in the top positions. You don't see women actively participating in decision making process of those corporations. So these are all called as fem washing. So this is something where a corporation on upright in an outside world, uh, they have this agenda that we are very serious about human rights, but they do exactly the opposite. So this is called business of human rights, because they understood that if they're not going to have a tag on human rights, they are not going to survive the market, because this is something which now the consumers are very much aware, because we see something called as there's a term called as ethicalism or consumer ethics, where these consumers are very much particular about what kind of product they are buying. So if they understand that particular corporation is indulging in child labor, they don't get that products. So if that particular corporation is indulging in environment disaster, they don't get this product. So they can't survive the market. So they are using human rights as a mechanism to capture the market. This is called business of human rights. We are slowly, migrating to that. And then, looking at what exactly the role of business in the society, the business as such has become a very much integral part of the growth of the society. You see, business plays a vital role in the growth of a country's economy. It contributes to countries' growth in GDP. It contributes in eradicating unemployment. It contributes in a country's infrastructural development. It contributes in goods and services. It contributes in innovation, technology. It also contributes in global interconnections and interdependence, because the whole concept of globalization, though we have types of globalization, the moment we hear the term globalization, the aspect that comes to our mind is trade, because it is only because of trade we understand the concept of globalization in a very different manner, because we know after 1990s, the moment India embraced the neoliberal political economy, the LPG crept in. We see a drastic changes. The moment LPG came in, there is a stark withdrawal of state from public sectors, say education, medical facilities, even now, the transports, the sorry, thing that happened with the Air India crash, because still when it was with the public sector, we didn't have these kind of very worst accidents. But unfortunate, it is very unfortunate that once it has become a private sector, we see a very horrible accident, which is very unfortunate. So after 1990s, we see that the state has withdrawn itself from these essential sectors and private players stepped into it. So you see these business people or the corporations play a vital role in shaping up the society, in contributing in many ways. So when this comes in, you are at one point, you have to hold yourself accountable for the actions what you did. So you can't say that no, protecting people's right, or guaranteeing a citizens rights, or remedifying citizens issues are not those of my role, but it is the state's role. So you can't just get away of what you have done, and you can't say that I'm not accountable, and you don't have to ask me to hold accountable, because when your rights are infringed, it is only the state that has to come into picture. That idea has slowly vanished in the international context. So now, why should business be concerned about human rights? It is because you are very influential. It is because it is not a moral obligation, but it is a fundamental necessity of a corporation to make yourself accountable. You have to be concerned about human rights. Protection of human rights are not only the duty of the state anymore. You have to take responsibility for whatever actions you have done. It is a combined, it is a shared responsibility of the state and the corporations, because state at one hand and the corporations on the other hand are the two strong pillars that are functioning the whole setup. The countries are run because of these two dominant setups. So the people are completely, dependent on these two structures, and hence you have to be responsible. There must be a shared responsibility between the state and the corporation. Why? Because we all know the horrifying incident that happened in 1985, the Bhopal gas tragedy. Till now, I would say I have listened to many senior professors on business and human rights. I have never uh, seen a professor not speaking on Bhopal gas tragedy till date. We are in 2025, but till date, every professor speak on that. Every research on making corporates accountable cannot go untouching the Bhopal gas tragedy. We know how horrifying it is. Still now, there are victims who are suffering from the impacts what that tragedy has given. So business operations have a very direct impact on human rights. So human rights violations are very much directly connected to the business operations. So not being concerned or not upholding human rights is not something which you are giving back to the society. You will not be labeled as you are socially responsible if you are not taking human rights as a serious issue, because you can see that corporates not holding accountable for the labor rights, say for example safety, say for example safety working place, safety infrastructure, paying them proper wage, or even acknowledging a trade union, which very recently happened in Chennai Samsung industry, where the South Korean corporation Samsung was not happy about the trade union, the labor union which was proposed, so which opposed them. There was continuous protest by the laborers. After a long protest and intervention of the Madras High Court, then this union was established. So, this is something which you are directly having an impact. 3 months, no work, no wage. How will those family, run? Because the all these laborers are dependent on this corporation, and you can't do that. So any actions what this corporation does has a direct impact on human rights violation. Environment, let's take the LG polymers leak in Visakhapatnam, or Bhopal gas tragedy, or the mercury leak in Hindustan Lever Limited, or the infamous Sterlite case in Tamil Nadu, Thuthukudi. All these corporations have a very lethargic attitude to protection of human rights, especially with that of environment. They did not take environment as a serious concern, which very badly impacted the in and around area, the people around in and around the corporation. And also with the rights of indigenous people across the globe, you see indigenous people are directly affected by a corporation. In India, I can cite a various example. One very well-known example is the Nyamgiri Hills in Odisha, where Vedanta wanted to exploit the bauxite resources, and it played very worse with the tribal community people there. Uh, Again, with the intervention of the Supreme Court, now the tribal people's right has been restored, but that had a very long battle as such. So when you look at all these aspects, any actions of a corporation has a direct impact on human rights, and now you have to be very serious about protecting and promoting human rights, and you cannot get away telling that no, it is not my responsibility and it is only state responsibility. So when this discussion happens across the globe, it is not only the case of India. Across the globe, you see whenever there is a small chance of exploiting the resources, exploiting cheap labor, you see a corporation making a lot of profit. So this was a serious discussion. And what happened continuously, the international jurists and international researchers on business and human rights, the professors, academicians, even the NGOs, they all came up together and they wanted some kind of a framework to address this concern. But unfortunately, what happened was, till date, we do not have a very strong international instrument which pose a mandate on these corporations for whatever human rights violations they have committed so far. But still, we do have a couple of international instruments which are very which has very nice guidelines, but they are all in guidelines nature and it is all voluntary in nature, but it does not pose any mandate on these corporations. So I'll just give you a very brief introduction to all these instruments. Maybe in another lecture, maybe I can use some in-depth discussions on these instruments. So starting from the UDHR in 1948, the uh, Universal Declaration on Human Rights, the 1948 instrument, which speaks on freedom, equality, and justice for all. So, which is considered as a mother document. We say that it is a mere declaration which does not have a mandate. It is a declaration, but uh, uh, on course of time, many of the countries within their domestic legislation, they have incorporated certain essence of UDHR. Even in India, with the Indian Constitution, you see these terms are very much inscribed within the Indian Constitution, which speaks about freedom, which speaks about equality, which speaks about justice. Similarly, across the globe, many of the countries have ingrained the essence of UDHR within their domestic framework. So now you can't merely say that UDHR is just a declaration, it does not bind us, because it has been entered into our domestic legislative framework. So we understand that it is a powerful instrument. I always consider UDHR as a mother document for human rights as such. So when UDHR says freedom, equality, and justice for all, you can't achieve this with only taking state accountable for guaranteeing freedom, guaranteeing equality, or guaranteeing justice for its citizens. So it can be done only by the combined effect of the corporations. Why? Because corporations are now growing equally stronger socially, economically, and politically to that of state. So UDHR says you have to promote rule of law. It focuses on stable rule-based society. Only that will support a smooth functioning of a business. So for a stable rule-based society, it is not only the states responsible, but also the corporations have to. As of now, we don't have a legislation forcing a mandate on them, but a corporation has to voluntarily think of protecting and promoting human rights. So applying a human rights principles thoroughly, consistently, and impartially in a company's global operations may contribute to fairness, equality, and justice. So the next instrument, this is the first instrument which directly spoke on the nexus of business and human rights. It is called the OECD guidelines, that is Organization of Economic Development Guidelines for Multinational Enterprises on Responsible Business Conduct. It was adopted in the year 1976. So it is something, these are the recommendations that came from the government to the multinational enterprises. So what was the aim of this instrument is that the multinational enterprises have to positively contribute to economic, environment, and social progress. So it actually encouraged responsible trade and investment to achieve sustainable development outcomes. So when we all know SDG goals, SDG, all these SDG goals, when you start comparing, you will definitely end up with business and human rights, because all the SDGs have something to do with one or the other corporate sector. So what the OECD says is that all these multinational enterprises have to provide voluntary principles and standards for responsible business conduct. And it has to be inconsistent with internationally recognized human rights standards. So you have to follow these. So when a country is embracing or adopting these guidelines, it has to make sure that it come up with a strong framework where the MNEs are positively contributing to economic, environment, and social progress of that particular country. So it has 10 chapters within it, which varietyly speaks on, disclosure, human rights, employment and industrial relations, environment, bribery, combating bribery, consumer interest, investing on science, technology, and innovation, and also complying with all the competition laws of that particular domestic setup. So this was the first instrument which directly spoke on how a multinational enterprise have to be responsible for being a player within the societal setup. How should it positively contribute to socially, environmentally, and economically progressive setup? So now how it should work. So it again it is a very mere guideline. But if at all a country is going to be a member of this, have adopted this, then there is one type of mechanism what OECD has. It is called as NCP, which is called as National Contact Points. These are not judicial mechanism, but slightly in the nature of quasi-judicial mechanism. where if there is going to be a corporation found violating a human right, uh, then that particular corporation can be reported in that NCP, and the NCP can, pass such and such order to comply for that particular corporation. But again, it is merely voluntary, and it doesn't have a standard mandate on all these corporations. So this was in 1976, and then in 1977, the International Labour Organization, it came up with a declaration. It's called as, in short, we used to say it is a tripartite, ILO's tripartite declaration. So what is this ILO's tripartite declaration? It is a tripartite declaration of principles concerning multinational enterprises and social policy. So what this ILO tripartite declaration said, it had, it constituted conferences, industrial committees, then international labor conferences. So this was the reflection of discussion that happened from 1960s. From 1960s, the discussion from various stakeholders, uh, they kept on repeating that with regard to labor and labor rights, what is the role that these multinational enterprises have to, take up? How sincere or how serious they should be with respect to protecting labor rights. So this particular tripartite declaration spoke on the labor rights. It encouraged a positive contribution which multinational enterprises can make to economic and social progress, in specific with that of labor rights. So again, this has four major parts, which speaks on employment, which speaks on training, which speaks on conditions of work and life, and then industrial relations. So in specific, if you see the whole document, everywhere it speaks on labors and labor's right. Starting from how they should be employed, how should be the promotion, or how you give equal opportunity to treatment in employment, how do you secure their employment, how are you focused in having a proper workplace environment, starting from wages, minimum wage, safety, health, and all these aspects. And you see, all these aspects are ingrained in our Indian constitution as well as the labor legislation, where we speak about equal opportunity in Indian constitution, where our labor legislation speaks about paying proper minimum wage, giving proper, workplace safety, all these is, and also settlement mechanism what our labor legislations have. And then this is in 1977. Then in 2000, this is called the UN Global Compact, which is very much active even these days. This was the brainchild of the then UN Secretary General, Mr. Kofi Annan. So he had this idea that came up in mind, that we see a continuous human rights violation in the business operations. The corporations are directly or indirectly contributing to human rights violations. So now what we do? So Mr. Kofi Annan thought that, okay, let us have something which will attract all these corporations together, and let us all take a oath that we will protect human rights and promote human rights, which instant shows the stand, the international stand, especially with that of human rights. What does these corporations have? So the moment you see, these are all called as blue washing, business of human rights. Blue washing. What is blue washing? Blue washing is something where you take up the tag of United Nations, and then you say that how sincere or serious you are with respect to human rights. So the moment you claim, a corporation claims that it is a member of a UN Global Compact, so the understanding is that you are very serious about human rights. You, the whole business operations of this particular corporation is going to be very concerned about upholding protecting or promoting human rights. Okay, so now what happened? It is now very it is claimed to be a very sustainable initiative involving at this point of time involving more than 20,000 companies and 3,000 business participants, and also 160 more than 160 countries are member of this UN Global Compact. So this UN Global Compact has 10 principles. So all these 10 principles have been derived from UDHR, the ILO's fundamental principles, the Rio Declaration, 1992 Rio Declaration, and also the United Nations Convention Against Corruption. So this 10 principle predominantly speaks on human rights, labor, environment, and anti-corruption. Because what UN Global Compact says is that you see corporations are very much directly involved in human rights, in the nature of labor, the nature of environment, and also anti-corruption. Anti-corruption is the very recently added principle within the UN Global Compact, because anti-corruption is something we see across, where it is either way it happens, the corporates sometimes, bribe the state or state authorities to establish their, uh, you know, uh, corporations. So they must work against corruption in all forms, including extortion and bribery. This is what the UN Global Compact says. Unfortunately, again, the UN Global Compact is a voluntary principle. It does not pose a mandate, even if you become a member of that UN Global Compact, unless otherwise you embrace these principles within your domestic framework. That doesn't pose any mandate. It is just a voluntary guidance. You may adopt these principles. So it is giving you a guideline that what kind of law you can frame within your country based on these principles. And then in 2003, this is something which is very crucial in the development of business and human rights. This is, we actually say it is a 2003 norms. So what is this norms? These norms on the responsibilities of transnational corporations and other business enterprises with regard to human rights. This is the first instrument which did not focus on voluntary principles, rather, it focused on a mandate. It said, if you are a corporation, when you are indulging in a human rights violation, it could be a direct involvement or an indirect involvement. You have to be held responsible for the actions you hold, especially with that of conflict zones. So let's take the African region. There's something we have to remember, that Africa is highly unexplored, but to the level of exploration that has made by corporations, it has been exploited to a greater extent. Be it cocoa, be it cobalt, or be it diamonds, be it gold, copper, you see a serious violation of human rights happens in these regions, especially in Congo, where you see when there is a very weak government, when there is a dictatorship or dictator government is going on, where there is no democracy, you see the corporations take that situations to their side and they exploit it. So especially in Congo, you see child labor exploitation, sex trafficking, and also exploitation of natural resources, complete eradication of natural resources, flora, fauna, deforestation, excessive mining. All these happens in these regions because the legislative framework is so poor and the government is so weak there. So, because that those places are taken up by dictators, it is easy for these corporations to exploit that situation. And you see child soldiers taking arms and fighting. So especially 2003 norms focused on these kind of conflict zones. So when a corporation is involving in these kind of conflict zones, these corporations have to make sure that it does not exploit the situation, does not exploit the labor, does not indulge in child labor, does not indulge in sex trafficking. Many child sex trafficking also happens in these regions where the corporations play a indirect role in exploiting the people in these regions. Apart from this, none of the international instruments pose a mandate making the corporations accountable for the human rights violations that they commit during their business operations. Now, presently, the very uh, strong instrument is called as the United Nations guiding principles on business and human rights. So this is after the failure of 2003 norms. The 2003 norms did not make up because the lobbying that was made by the corporations with the state was that we don't want to take up any responsibility. So none of the instruments can pose a mandate on us. So this did not make up. So this 2003 norms was completely brushed out. And then in 2005, what happened? The United Nations appointed Professor John Draghi from the Harvard University to come up with an instrument which speaks on business and human rights. So now this is the one instrument which hold in its title in itself the term business and human rights. So this document was adopted in 2011. So Professor John Draghi was a special representative of the Secretary General on Human Rights and transnational corporations and other business enterprises. So he did this till date. This document is the largest empirical study across the globe done on business and human rights. So when Professor John Draghi came up with this instrument, he came up with three pillar concept. So what is this three pillar concept? He said, see, we have lots of international instruments. We also have some very good human rights legislations in few countries, but none of them could achieve better because we were not able to come up with a pragmatic solution, which is called as a practical solution. Something seems very unpractical. We can't really achieve these things. So he says that a practical solution to look into the nexus between business and human rights is that we will have a three pillar concept that is called protect, respect, and remedy. So, what is this protect? The first pillar speaks on protect. The state has to protect human rights. So it says the state's duty to protect human rights. And then the second pillar is called the respect pillar, which means the corporate has the responsibility to respect human rights. And then the third pillar is the access to remedy. So access to remedy has to be a combined effect of state and corporation. So the moment when you say access to remedy, not necessarily the access to remedy should be a judicial remedy. It could be a non-judicial process where remedy can be accessed, or it could be a quasi-judicial process. So it could be different types of mechanism where the victims can access to remedy. It depends upon the situation. It could be tailor-made, where the state as well as the corporations can held themselves responsible. So in total, this document has 31 principles, which is divided into three parts: uh, uh, the protect, remedy, sorry, the protect, respect, and remedy concept. So these are all the international setup we see with respect to business and human rights. And slowly diving into the Indian context, we see something called as National Action Plan. So this national action plan, we do not have a national action plan so far. So in the year 2019, the Ministry of Corporate Affairs, the Indian Ministry of Corporate Affairs, came up with a zero draft on National Action Plan. So, what is this zero draft of National Action Plan? So, this National Action Plan was designed on par with that of the United Nations Guiding Principles 2011, which was drafted by Professor John Draghi and his team. So, what actually the National Action Plan has to do is the concept of National Action Plan comes from the UNGPS. So, it says that what is the action plan that a country is going to have in order to address the business and human rights nexus. So it says there must be four ideas that has to be inscribed within the National Action Plan. Number one is to that National Action Plan has to be derived from the UNGPS. Second, it has to be context specific. Why? Because the issue of business and human rights in Africa is different, in India is different, and in Sri Lanka it will be different. So you cannot have, see, that is what one size doesn't fit all. Every country has a different socio-economic and political situation. So according to that situation, it should be very context specific and it should address only that country's actual and potential business related human rights abuse. This is number two. Number three, it says that the National Action Plan has to be developed in a very inclusive and transparent manner. Why? Because whenever we say there is going to be a committee constituted in order to address indigenous people's rights, we don't see representations from indigenous people community at all. So it must be inclusive. So whatever issue that the state has to take account, that issue has to have the respective stakeholder inclusively, and the mechanism has to be very transparent. And the fourth final one is that okay, you cannot just get away saying that okay, I have drafted a national action plan. That's all. My job is done. No, there must be a regular revisiting of that document and you have to review it in a very regular manner and you have to update it accordingly because yesterday there must be some problem, so you come up with a document telling that I'm going to address it in such a manner, but today you have a totally a different manner and that the yesterday's document does not fit today's problem. So you have to revisit and review it occasionally in a very periodical manner. So far we can see that almost 34 countries across the globe has come up with a concrete national action plan. Unfortunately, India has not come up with their national action plan so far. So the 2019 zero draft is still in the zero draft stage itself, and we do not have a concrete document on business and human rights till date. Before the National Action Plan, we did have a few other documents called as NVGS. So it is the National Voluntary Guidelines Principles 2011 and 2019, and then so 2018, and then which was revisited, and the National Action Plan Zero Draft came in. But still now we do not have any concrete document on business and human rights in India. So we may have different legislations in the form of environmental legislations or the labor legislations or our own Indian constitution. But now the need of the hour is that we need to have a very specific legislative mandate that is directly concerned or directly addressing the human rights abuse that is caused by business or the business operations. Not necessarily, I'm not a great fan of, enacting new legislations every now and then. We can have some insertions, amendments to the existing legislation. Say, for example, in China, within the human rights legislation, the National Action Plan has inserted as a chapter within the human rights law. So, something of that nature, India can also revisit and rethink that we come up with a proper legislation which very specifically look into the business and human rights aspect as such, because every now and then, every day we see, directly or indirectly, corporations are indulging and infringing human rights, uh, and people are suffering from the corporate's action. We see protests everywhere happening. We see people are dying. I can say I'm from Tamil Nadu. I can say my own state has a great list of corporate abuses that happens every now and then. Starting from Sterlite, Kudamkulam, or any other nuclear power plant, the Kodaikanal HLL Mercury, or very recently the ship that sunk, the Elsa 3 here in Port Village in Kerala. These are all some strong message that we are getting, that it is not only the Bhopal gas tragedy that shook us, that every now and then we see that the corporations are indulging in some kind of activities which are directly or indirectly affecting us. It could be today, it could be the people of some tribal community who are being affected, but slowly that could be entering into our own face. Our own consumer rights will be violated. Now, in this situation, it is all of us that we should be very vigilant enough that it is right time, it is a prime time. Looking at the accidents in Virinjam Port or the accident in Ahmedabad, we need to be very serious about how these corporations are going to held themselves accountable. So, with respect to, let's take the Ahmedabad, flight crash. Now, immediately, the moment the flight was crashed, immediately the Tata Group said that we will be giving 1 crore rupees to every people who were there in the flight. Now, there was a family where all the family members, that was so sad that the three kids and the mother and father, the five of that family, all of them died. Now, who will have that 1 crore, and what will they do with the 1 crore? Now, how are you going to hold yourself accountable? Just giving compensations or just remedifying your fault with money? Will that get away with the negligence, or that will that get away with your responsibility over the people around? You can't just say that. I had one of my students here in Tamil Nadu National Law University, who is from Bhopal, who, when we were discussing business and human rights in the class, he said, "Ma'am, I still have that impact of that leak. He was not even born when the leak happened, but his parents were there. After, a couple of, I would say a decade or a decade and a half, this kid was born. But this kid is still suffering from some kind of allergy in his skin. All of a sudden, he will not be able to come to the class because he will feel sick. The doctors will not be in a position to even understand what this child is undergoing. The trauma what these people, till date he used to say, my mother cannot come out of the trauma because she saw her brother dying because of that accident, Bhopal gas tragedy. They saw people dying in front. You can't get away with these kind of trauma. Now, in all these situations, how, as a corporation, are you going to be accountable? Not just giving money will take away the trauma. Will that take away my trauma? If I see someone doing that, there was a person in Bangladesh. He was an activist. When the Rana Plaza massacre happened in Bangladesh, people were within the building which collapsed. 1 week, it took nearly 1 week for the state to clear the debris and take out the bodies from those collapsed buildings. So this activist who was indulged in the rescue mechanism, he went into a trauma and he stopped speaking to people. And at one point of time, he committed suicide. So he was not there in the building. He was not in no way connected to that business operation as such. But indirectly you have contributed to his death. Now, in all these situations, how are you going to hold yourself responsible? Now, what kind of mechanisms do we have to act as remedy when these kind of corporations are not taking themselves accountable or responsible for the actions what they have done? Now, today, I think, today or yesterday, we got the report of what happened in the cockpit. So it is again highly debatable. So now they are forcing the burden, or they are passing the buck to the pilots. Now they say it is the pilot's mistake. Even if it is the pilot's mistake, whose responsibility it is? When you are sending a pilot, how responsible you should be in taking care of how this pilot physically, mentally fit. There are lots of discussions on that. Now, you can't just, pass your buck or tell that I am not responsible. Okay, if I do something wrong, I'll give you money. That cannot be the case. Now, we have to have some strong mechanism to make things right, to make these corporations liable for what they do. So maybe if I get an opportunity, we may ponder upon all these aspects in details in future lectures. But I just wanted to give an introduction to how this concept works in and how law plays a role in this concept. So maybe I will stop my lecture by this. If anyone have anything to ask, you may ask. I hope it was useful.
Yes, ma'am. I was just checking it out
Yes, sir.
on the YouTube if we can find something. No, there are no questions. Probably it is one of the niche areas. In a lot of universities, this topic is actually incorporated in the syllabus also. But you have delved deeper into it, and we have all actually enjoyed it. Thank you, ma'am.
Thank you, sir.
Yeah,
Thank you, sir. Thank you so much.